Hello, Business Law 1 students. Welcome to Unit 6, the final lecture for the course called Agency, and we're going to be covering the remaining chapter of 23. It's titled Chapter 23B. Let me read a scripture for us before we begin. 1 John chapter 5, verse 12 and 13. It reads like this. Whoever has the Son has life. Whoever does not have the Son of God does not have life. I write these things to you who believe in the name of the Son of God, so that you may know that you have eternal life. So be sure to put your trust in the right one. All right, we're going to move on into the lecture here. It's not very long, but I feel like we do need to make sure we cover the entire outline. Last time I spoke, I talked about that you need to review. We went over tort liability in pretty much some good detail. The next topic is government obligations. There'll be a couple questions with regards to that. And basically, you just need to read through the chapter and go over what obligations does the employer have with regards to withholding what the government wants to withhold. For example, state income tax, federal income tax, Social Security, unemployment insurance, those types of things. Now there could be additional withholdings, for example, for your health care, etc. So know those, and also know that when a principal withholds those types of items from the compensation to the agent, that's one of the indicators that this is an employer-employee relationship as opposed to an independent contractor. So keep that in mind. But what's the most important indicator of whether they're an employee or an independent contractor? The most important is the control of the work product of the agent. How much control does the principal have over the agent? Big indication of whether they're an employee or not. The next item are the duties between the principal and the agent. They each have a set of duties that they owe to one another, and it's pretty much a listing that is very easy to understand. So, for example, the duties to the principal are the duty of loyalty, the duty to notify them, the duty to keep an account of what they do. And so there's a whole listing of that. And then on the flip side of that, the principal has a number of duties to the agent. One of the primary ones being the duty to pay them, to compensate them, the duty to reimburse them for whatever expenses they paid on behalf of the principal. And so there's a whole nother list of duties that they owe to each other. All right, very straightforward in the text. The last topics that I want to cover that are need a little more explanation is contract liability. We had already mentioned that there's a tort liability with regards to the principal and the agent, but there's also contract liability. In other words, the agent can enter into a contract and the principal could be liable for what contract the agent entered into. And so that's what we need to get into. And the two key aspects that we need to look at with regards to this is the authority that the employee has to act on behalf of the employer. And then the other aspect is the agency disclosure. Has it been disclosed to a third party that the agent is acting on behalf of the principal, who the principal is, or whether the agent is acting without disclosing at all that they're representing a principal. So those are the three kind of environments that an agent could be acting in, and it has an influence on holding the principal liable for what the agent is acting on behalf of. All right, so moving on, we're looking at three, but we're going to say two types of authorities, okay? There's actual authority and then apparent authority. Now, actual authority can come into two forms. It can be expressed authority. For example, like when you hire a real estate agent, you have a contract, an agreement between the buyer or seller and the agent. The buyer or the seller is the principal, all right? And they have hired this real estate agent, who is not an employee but an independent contractor, okay, to act on their behalf. And those directions are expressed in that contract. There's also implied authority that goes along with expressed authority. So in the example here, let's say I hire you to be my manager of my store, my ice cream store, okay? And we have an employment contract, but it doesn't detail out everything. It doesn't detail out that you have the authority to buy supplies. And so you go ahead and contract with a third-party ice cream supplier, all right? Well, it's not in the expressed authority, it's not in the contract, but it's implied based upon the position that you hold as my manager for my company. All right, so that's called implied authority. Other kind of a side rule that you need to be aware of called the equal dignity rule. Equal dignity rule basically states that if the contract that the agent is entering into is in writing, then the agency agreement between the principal and the agent must be in writing. All right, so just understand that. Otherwise, the contract executed by the agent is voidable on the part of the principal at their option. All right, I mentioned there's one more type of authority. It's called apparent authority. And let me read the definition to you from your PowerPoint, page 4. When a principal, by words or actions, causes a third party to reasonably believe that an agent has authority to act, even though the agent has no express or implied authority. So, say, for example, you're in the presence of a third party, perhaps a supplier of some inventory that you normally buy. And you, the agent, and the principal are in the same presence as that supplier. And the agent does not have express authority and does not have implied authority because they're not in that position. But the principal makes it appear to the third party, makes it reasonably appear to the third party that the agent has the authority to act on your behalf. And if that is done, then that's called apparent authority. And this is authority derived from the perspective of the third party. And if that is the case, then that can also bind the principal to what the agent does. All right. So, we look at the three environments of disclosure, and now we're looking at authority. And I'm on page 5 of the outline, and this is probably the most important page with regards to this session. Okay. What we're going to do is combine the disclosure environment that the agent and principal are in and the authority given, and then we look at the general rules of who's liable. So we'll just walk through with me, and hopefully this will you'll be able to understand it more so. So once again, I'm on page 5, PowerPoint number 6, titled The Authority of the Employee to Act on Behalf of the Employer. Disclosure of the principal to the third party. The general rule is a disclosed or partially disclosed principal is liable to a third party for the contract made by an agent who is acting within the scope and course of employment of their authority. Sorry for all the background news. We got phones, we got babies, and we got dogs. So once again, let's read the general rule again. So when we say disclosed or partially disclosed principal, what that means is the agent has indicated that they are acting on behalf of a principal. And if they are fully disclosed, then we know who the principal is. So from the third party's perspective, they know that this agent is acting on behalf of the principal. And if that's the case, if it's a disclosed principal, then the principal is liable only and not the agent. All right? If it's a partially disclosed principal, that is, the third party, the supplier, knows that the agent is acting on behalf of a principal but does not know who the principal is, then the rule is the principal is liable and the third party can also hold the agent liable. All right? And then the third situation is undisclosed principal. In this situation, the third party is dealing with an agent, and the agent is representing himself. He's not indicating that he's acting on behalf of a principal, and he is not indicating who the principal is. Okay, so from a third party supplier perspective, let's say, there's no indication that this agent is acting on behalf of the principal. In that situation, the general rule is the agent is liable, and if the agent was authorized by the principal, then the principal will also be liable. If the principal did not authorize the agent, then the principal is not liable to the third party. So, hope that makes sense. Finally, last part of the lecture, and it's pretty straightforward as well, and that's termination of the agency relationship. Okay, when does this agency relationship end? Well, we divide that into two major categories: acts of the parties and then by operational law. By operational law means by law the agency terminates. So, by acts of the party. If time lapses, let's say I hire a real estate agent. Normally within that agreement, there's a time certain that the agency relationship is good for. Once that time lapses, then the agency relationship ceases. If no time is indicated, then it's a reasonable amount of time. That depends upon the type of contract that you're dealing with. Next item, accomplish a particular purpose. Let's say I hire that real estate agent. He finds my house, we close on the house, boom, the agency relationship is ended. Occurrence of a specific event. Let's say I hire you to find tickets for me for the Chicago Bears game by a certain date, and that game comes and goes. That specific event has occurred. Could be mutual agreement. We could come together verbally and agree the agency is over, or it could be written in the agreement. Renunciation or revocation, either of the parties just revoke the agency agreement. So by agreement, they agree to separate ways. The last area is operational law. All right, either death or incompetence of either of the parties, just as you can read there in your outline. Impossibility of performance. Let's say, once again, I hire a real estate agent to buy my house, but the house burns down. Okay, if the house is destroyed, the agency agreement terminates. Materially change of circumstances. Let's say I was hired a real estate agent to sell my home because I'm going to take a new job in some other location, and that job falls through. Basically, I don't want to sell the home anymore, so I renunciate the agreement based upon those change of circumstances. And then finally, bankruptcy. If either of the parties is bankrupt, either of the parties, by operational law, terminates the agreement. So the last page, very straightforward. The bulk of your questions are going to center around the authority of the employee to act on behalf of the employer in the different environments of the disclosure of whether there's an agency agreement or not. And then the other group of questions primarily are going to be about authority and the different types of authority: expressed authority, implied, and apparent authority. All right, I hope that helps guide you in preparation of the exam. I'm rewriting the exam in light of these lectures to just get a pulse on, do you understand the basics of agency law? All right. Appreciate it, and hope you have a great day. Stay healthy. Talk to you later.